All right, guys, from the very start, you can feel the tone. This isn't just another hearing. It's a slow-motion train wreck. The defendant ditching legal counsel after a questionable confidence boost sets the stage for everything that follows. There's a difference between understanding your rights and overestimating your ability to defend them. And right here, before a single legal argument is made, you can already sense that this decision is going to cost him big time.
With us, Ms. Spradlin?
Yes, Mr. Brem has indicated that he does not wish for the assistance of the public defender at today's bond hearing, and I advised him about his right to remain silent.
Okay. And so, Mr. Brem, my understanding is that you're waiving your right to counsel with respect to the hearing today. Is that correct?
Yes, Your Honor.
Okay. Mr. Brem, do you need further reading or advisement regarding the charges? I can do that here quick. It looks like, let me pull up the warrant here. Just give me 1 second. The charges are possession of a weapon by a previous offender, which is a Class 5 felony. That's punishable by 1 to 3 years in prison. Could be as many as 6 with aggravating circumstances, 2-year term of parole, and up to a $100,000 fine. You're charged with protection order violation, 5 counts of that. Each is a Class 2 misdemeanor. That's up to 120 days in jail and up to a $750 fine. You're charged with possession of a controlled substance as a Class 1 drug misdemeanor. That's punishable by up to 364 days in jail, up to a $1,000 fine. There's a $1,000 drug offender surcharge and 24 hours of useful public service. And then you're charged with possession of drug paraphernalia, 5 counts of that. That's a drug petty offense. It's punishable by up to a $100 fine and 16 hours of useful public service. Do you understand those possible penalties, sir?
Yes, Your Honor.
All right. Concerning bond and the protection order, Ms. Shisham.
Thank you, Judge. In this case, we're actually asking the court to increase the cash.
Now we move into the formalities, and the judge is doing exactly what they're supposed to, making sure the defendant understands what he's giving up. But here's the catch. Waiving your right to counsel isn't just a checkbox, it's a gamble. And the defendant casually agreeing, without hesitation, shows a lack of awareness about the complexity ahead. This isn't a debate club, it's a legal battlefield, and he just walked in without armor.
Bond that is previously set. The reason for this request is that Mr. Brem has 6 prior felony convictions, and he posted surety bonds in 2 cases in Garfield County that are pending, one for possession with intent to distribute and the other for distribution. He now has 12 pending charges along with protection orders and these bonds, and even in light of that, he is in the possession of 3 long guns and ammo. He is made it clear he's not going to abide by court orders, and we believe him to be a threat to community safety. So we would ask that the bond be increased from the $5,000 cash bond that was set. We're asking for a standard protection order, no firearms, weapons, or ammunition, and relinquishment, no drugs, pretrial services, and testing.
All right. Thank you, Ms. Shisham. Ms. Spradlin?
Yes.
Wait, no, sorry. I'm Mr. Brem. I forgot you were representing yourself on this, Mr. Brem.
Yeah, so I'd ask the courts to lower my bond. I have community ties. I'm taking care of my mother at the house. In regards to the other cases, they're being suppressed and being dismissed. As far as this case, it was an illegal seizure. I wasn't even in the vehicle when they arrested me or when they came up to me. So the vehicle was an illegal seizure. It was against my Fourth Amendment rights. I just asked the courts either modify the bond to a PR bond or lower it to a just reasonable amount that I could post. I have no intentions of running or being a flight risk. I plan on taking care of this. And I work with my brother. He keeps me busy. And then when I'm not there, I'm helping my mother. She's older, has heart problems, and I'm the only one there to take care of her.
This is where reality starts hitting. The judge lays out the charges one by one, and it's a heavy list: felony, multiple misdemeanors, drug charges. Each carries serious penalties, and combined, they paint a very troubling picture. The defendant says he understands, but understanding words isn't the same as grasping consequences. This isn't minor trouble. This is years of potential prison time stacking up fast.
Or danger to a specific person, In this particular case, the court would note that Mr. Brem has 33 lifetime failures to appear, only 4 in the past 5 years, but that certainly is something that's concerning to the court. The court also notes that Mr. Brem has a very extensive criminal history that includes similar types of allegations in the past. He's currently out on bond on multiple cases where he's charged with felony offenses, serious felony offenses, including distribution. The allegation is that there's some drug involvement in this particular case combined with possession of a firearm, which is certainly concerning from a community safety perspective. The question is whether or not those concerns can be mitigated through non-monetary bond conditions. And looking through the criminal history, the court determines that they cannot be managed through non-monetary bond conditions. Mr. Brem, from this court's perspective, it's an in or out decision. I either set a PR bond with conditions, or I set a very high cash bond that's designed to hold someone in custody. And so in this particular case, the court is going to go for the latter. I am going to set a high cash bond that is designed to hold you in custody, at least right now. You will be able to litigate those suppression issues that you mentioned beforehand. And obviously, I'm not going to be your assigned judicial officer. It's going to be Judge Barrett. And so right now, what the court is going to do is set a $25,000 cash-only bond in this particular case.
The prosecution steps in, and their argument is sharp and strategic. They're not just listing charges. They're building a narrative of risk. Prior felonies, pending cases, weapons possession, it all adds up to one thing: danger. And in bond hearings, perception matters. They're framing him as someone who doesn't follow rules. And once that image sticks, it's incredibly hard to shake in front of judge.
I am going to make a requirement of the bond that if Mr. Brem posts it, he report to pretrial services supervision. A condition would be no use or possession of controlled substances without a doctor's prescription, no use or possession of marijuana without a valid medical marijuana card, and pretrial would be authorized to test to make sure that Mr. Brem's in compliance with that. The court is also going to order that Mr. Brem not possess or use weapons or ammunition as a condition of his bond. I am going to issue a mandatory protection order that says that Mr. Brem shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that he's charged with committing. Further, he cannot possess, purchase, or control a firearm or other weapon or ammunition as part of this mandatory protection order. Mr. Brem, do you understand those conditions of the mandatory protection order?
No, I don't understand any of this. This is unjust and unreasonable.
Why do you not understand that you can't harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you're charged with committing? What's not
I do not consent to any of this. I don't consent to these proceedings. I'm here under special appearance.
You don't need to consent to it. I'm just asking if you understand that, sir.
No.
What if he has a consent of surety from both bondsmen?
That's a separate issue. A consent of surety would be in those other cases. I don't know who that is or how they unmuted themselves. I thought that we had this on so that people could not unmute themselves. That does appear to be the status. I'm not exactly sure what's going on. So anyway, the court declines to address that. We're not going to be talking about reinstating any sort of other bonds or having a consent of surety. And so that's what the court is going to do. Mr. Brem, I do need to advise you that if you were to violate the mandatory protection order, you could be punished for contempt of court. You could be charged with a misdemeanor, or you could be charged with a felony for retaliating against or intimidating a victim or witness of the crime charged. This case is assigned to Judge Barrett's division, Mr. Brem. And so what we're going to do is bring you back to court for formal filing on Thursday, January the 29th. At 8:15 a.m. At that time, you'd be able to readdress that issue of bond in front of your assigned judicial officer. Mr. Brem, would you like us to appoint counsel to represent you on this case so they can help you with that bond argument?
No, I don't consent to any of this.
Okay. Well, at present, we won't appoint the Office of State Public Defender to represent Mr. Brem based on his wishes, but you'll be back in court on January 29th at 8:15 a.m. All right. Well, that concludes this hearing then for today, and so...
Now, the defendant speaks, and this is where things start slipping. He leans on personal responsibility, family ties, caring for his mother, but then pivots into legal arguments about a legal seizure. The problem? This isn't the time or place for that defense. Bond hearings focus on risk, not trial arguments. He's trying to fight the wrong battle at the wrong moment, and it weakens his position instantly.
In this case, Mr. Brem has 6 felony convictions. The most recent 2024. He's currently on surety bonds in 2 felony cases out of Garfield County. He was found in this case with 3 firearms and a knife, which are violations given his prior felony status. He has 4 failures to appear in the last 5 years, 33 in his lifetime. So I have community safety concerns and court appearance concerns and would object to modification.
There's also another case. I think he may have been issued a summons for possession of a controlled substance at the time of his arrest in this case. It's not on the CPAD.
Your Honor, I elected to combine those 2 cases.
Oh, okay.
I felt like there were double jeopardy concerns separating them because it was all kind of in part of one incident. So the charges in that separate affidavit are compiled into this singular case for Mr. Brem.
Okay. I guess you haven't dismissed that case yet, though.
Oh, if it's still pending, I will make sure to do that. I thought it hadn't been filed, so I will.
There's a 26M 232 that is a controlled substance and protection order violation case. And Higgins is the one who wrote the ticket. I don't have any information other than that within the file. But
if you want to call that case, Your Honor, I would just dismiss it on the record. Otherwise, I'm going to file a dismissal.
no, I'll let you look at it and make sure that that's what we're all talking about, the same thing. So the primary purpose of bond is to ensure that a defendant appears at each and every future court date. Other purposes of bond are to ensure compliance with conditions of bond as well as community safety and victim safety. When fixing bond, I do consider a host of statutory factors. I've considered them all here, even though I may not mention them. The statutory factors include, but again, are not limited to ties to the community, criminal history of appearing for court, and considering any empirically based scoring instrument that may assist the court in understanding the defendant's risk level should he or she be placed on bond. The defendant didn't complete the empirically based scoring instrument. He refused to do so, so I don't have a score for him, but I would imagine it would be, at least in my mind, close to a category 4, if not a category 4, indicating the highest risk to fail while on bond.
The judge cuts through everything with precision. Bond decisions hinge on 3 factors: flight risk, danger to the community, and danger to individuals. And when the judge mentions 33 failures to appear, that's a devastating statistic. It doesn't just suggest unreliability, it screams it. At this point, the outcome is practically locked in because trust is already gone.
Due to a host of different factors. One, he was on bond in 2 different cases. At the time, he was contacted by law enforcement in this case. One involved possession of a controlled substance as a class 3 drug felony. And there's also a class 1 drug misdemeanor there. That's Garfield case 5017 from last year. Then in early January, there was a warrant issued for his arrest. He's now been charged in that case for class 2 drug felony, possession with intent to distribute. He has 33 lifetime failures to appear, indicating a high risk to not appear at future court dates. I will acknowledge, however, that of those failures to appear, only 4 of them are in the last 5 years. He was also on summons in a lesser traffic offense from earlier this year. The allegations in this case are very serious and involve the defendant allegedly possessing a number of firearms as a prohibited person. In addition to the possession of the firearms, there were a number of other very concerning items found within a vehicle he was alleged to have possessed: a skeleton key, numerous different types of drug paraphernalia, bolt cutters, and the like. He has 6 prior felony convictions, one of which is a vehicular eluding conviction, indicating, in addition to those failures to appear, a high risk of flight. I also am familiar with Mr. Brem. He was in front of me some years ago where he had chosen to represent himself and ultimately received a 4-year sentence to the Department of Corrections. He had a number of other cases pending at the same time in Garfield County, just as he does now. The bond in this case was set at $25,000 cash only. That is a very reasonable bond in the court's mind. We're talking about guns, drugs, 3 felony cases of serious nature being opened in the last year, or substantially less than that. We have a history of failing to appear and an aggravated criminal history. The defendant was given chances on not 1 but 2 different surety bonds before he picked up the charges here. Clearly those aren't working, so another surety bond would not meet the purposes of bond. Court has concerns about all of those statutory factors and the primary purposes of bond being met.
Now the bigger picture unfolds. Extensive criminal history, ongoing felony cases, and now weapons involved. The judge isn't just looking at this incident. They're looking at a pattern. And patterns matter more than promises. The defendant says he won't run, but history says otherwise. In court, history almost always wins that argument.
Several years ago, as I alluded to, I didn't allude to it, I said it, it didn't go well for you. You ended up with 2 years in prison consecutive to another case that you were serving from another jurisdiction, if I believe correctly. I went back and looked at the minimus. I'm going to go over the same questions I went over with you then, and I'm going to tell you a lot of the same things I tell you then. And the reason I'm bringing up what happened in that other case is because it didn't end well, you representing yourself. History is usually a good indication of future success. Ms. Marasich is an excellent lawyer. She knows what she's doing. I've seen her in court. I've seen her in trial. I've seen her get good results for clients in trial. You don't want her to be your lawyer? That's fine. I'm not going to stand in the way of you making that decision because it's yours to make. But I'm not going to let you make that decision without a full awareness of a few different things. Once we go down this road, sir, there is no turning back.
Here comes a decision moment, and it's blunt. The judge makes it clear. This is an in or out situation. Either release with conditions or set a bond high enough to keep him locked up. Given everything presented, the choice is obvious. And just like that, the bond jumps to $25,000 cash. That's not just a number, it's a statement.
You change your mind in a week because you file a bunch of motions that I deny because they're baseless, because you don't know the law, because they're procedurally incorrect, and you want her to come back and do it right? Not happening. You want advisory counsel? Don't count on it. You want to do this alone? You're doing it alone. You don't have the right to advisory counsel. You want to hire a lawyer to represent you? That's fine. You can pay out of pocket and get a lawyer at any time. What I am talking about, to be clear, is Ms. Marasich and the State Office of the Public Defender. Once you make this decision, like I said, there's no turning back. Do you want me to go through this questioning with you now for you to make this decision? Do you want to spend a few moments to talk to Ms. Marasich about what it is you want to do? Or do you want to read something from a sheet of paper that looks like you want to do?
Yeah. I understand the risks the court has outlined. I'm making a knowing, voluntary, and intelligent waiver of counsel under Feretta versus California. I've already successfully litigated a suppression hearing in Garfield County, which is basically the merits of this case. So,
what case was that, sir?
2025 CR 5017.
The conditions pile on. No drugs, no weapons, strict supervision. These aren't suggestions, they're legal boundaries. And when the judge explains the protection order, it's straightforward. But what stands out is the defendant's reaction. He claims he doesn't understand. That's not confusion, that's resistance. And in court, resistance doesn't play well.
I will appoint a lawyer to represent you.
Yes, sir.
You understand the penalties you're looking at in this case, sir?
Yes, sir.
Really? What are they?
Well, I believe, what is it? 2 to 6 with mitigating factors. Aggravated is 6 to 12.
It's 1 to 3,
Oh,
up to 6 years on counts 1, 2, 3, and 4. So 1 to 3 years in the presumptive range, all the way up to 6 years in aggravated circumstances, as well as 6 months in mitigated circumstances. So combined, the total sentence you could potentially be looking at would be, 24 years. If you were maxed out on each and every offense. But then you have a number of misdemeanor charges. Do you know what the penalties are for those charges, those class 1 misdemeanors?
not off the top of my head, Your Honor, but I've been told about them already. But again, this is all based off of an illegal seizure of my truck.
We'll figure that out at a later date.
Okay.
364 days of jail on each protection order violation. The drug misdemeanor, class 1, I think that's 180 days if it's a first offense. The drug petty offenses, of which there are a few, that's up to 10 days in jail on each offense. Do you understand those possible penalties?
Yes, sir.
2 years of parole, to be clear, would follow your sentence to the department on counts 1 through 4. Do you have any legal training?
No, sir.
Okay. How far did you go in school?
A little bit of college.
The "I don't consent" line comes out, and this is where things turn almost surreal. Courts don't require your consent to operate. That's not how the system works. The judge stays composed, but you can sense the disconnect. The defendant is operating under a completely different belief system, and it's putting him at a massive disadvantage.
Okay. When did you graduate from high school?
2011.
And where'd you go to college?
Community college in Rifle.
Okay. What'd you study in college?
Well, I only did a semester, but I was going to try to be an engineer.
Okay. You were successful in Garfield County with some motions issue. That's good. So you have some experience of the criminal law. We've already talked about you being in front of me before where things didn't go as well for you. So you have adverse experiences with the criminal law. Do you understand that the criminal law is a very complicated area and that people go not only to college, but graduate from college and then go to law school, graduate from law school? That's 3 years. Then they have to take a test that you have to pass. That's not easy. That a solid percentage of folks in Colorado fail even after all that schooling. And then after that, once they become a lawyer, in order to end up in this courtroom as a prosecutor or a public defender, generally go through several years of experience as a lawyer. Do you understand that it's a complicated field? It takes a lot of education, takes a lot of experience to be proficient at this work.
I do understand that, Your Honor. But I feel like I'm the best one to present my own case because I'm the only one that's basically there. And yeah.
Okay. Do you know most people would say that's why you're not the best person? Do you ever heard the phrase, the person who represents themselves in court has a fool for a client? You ever heard that before?
I have not, Your Honor.
It is a phrase.
Okay.
And do you know what it means?
The judge wraps it up with warnings, violate the order, and things get worse. Much worse. There's still an opportunity to get legal help, but the defendant refuses again. And that's the recurring theme here. Every chance to improve his situation is declined. It's not just bad luck, it's bad decision-making repeated.